Amber Heard's opening brief in her appeal has been filed, so now we get to see what the finest lawyers that travelers can buy can do for her. Let's take a look. So, just like it was for Johnny, this brief is Amber Heard's opportunity to make a first impression on the Court of Appeals. This is her chance to come in and try to grab them and hook them with a legal problem or an injustice that they can get excited about, that they could get interested in. And so when we turn to her table of contents to see what is she going to be giving us in this brief, the first thing that really jumps out is the fact that, yeah, she really is cramming all 16 of these assignments of error into one 55-page brief. Now, when she first filed her assignments of error, I pointed out that this is going to be a challenge because you have very limited space to be able to develop your arguments and to cover everything that you're going to need to cover in order to make your argument persuasive. So one of the things that they've done here that I will give them a lot of credit for, they have really refined this brief down to the absolute bare bones to be able to get everything in. They've done an outstanding job of organizing the argument, of presenting it in a way that is minimal. It includes very little extraneous fluff, although there certainly is some. And by and large, it sticks to the core of the points that it's trying to make without running real far afield. The challenge, though, is that in the law, the devil is always in the details, and particularly when you're dealing with some fairly complex legal issues. For example, if you're going to raise a lot of evidentiary issues, there's a lot of it depends that's always going to go into that analysis. Should this particular piece of evidence have been admitted? You have to go through an analytical process to demonstrate, here is what I was using it for. Here is the context in which I brought it up. Here is what it was responding to. Here is what they said that I believe opened the door for me to be able to do this. Here is what it would have been. Here is the impact it would have had on the outcome. There's a structure for legal writing that is taught to most, first or second year law students in law school. It's called IRAC, IRAC, Issue, Rule, Analysis, Conclusion. And so they have followed the IRAC form pretty stringently here. One way to achieve that in an appellant's brief where you have limited space is you basically use your headers, your subject descriptions here to state your issue, and then move straight into your rule of law and into your analysis. And so because they had such little space to work with here, that is the format that by and large they followed. They also did it, from my perspective, very well. One of the things that I would point out here with their topic headers in particular, their issue statements, they have done, in my opinion, a better job than Johnny did in crafting these issue statements. And one of the big standout things that I can identify is the use of this word because. Because is a critical word in analysis. If you just come out and say, for example, here in subsection B, the trial court should have dismissed Depp's claims, you're not really telling the court anything except I want an outcome. You're not giving them any part of the rationale for why they should go there with you. But you throw in that because, and now the court understands, oh, this is the real issue that we're talking about, not not just whether there should be a remedy available here, but whether there was an actual error and what the nature of that error is. So that was very efficiently done. I thought they made it very clear what they were going to be presenting and the general, at least, framework that they were going to offer for the analysis of their issues. Another thing that we can see really clearly from the table of contents is which issues they have prioritized. And we can tell simply because if you've devoted the space to it, that's probably the issue that you want the court to pay the most attention to. Since you don't have very much space to be able to flesh out any of these arguments, the ones that you've spent the most time on are probably the ones that you think you have the best shot at winning. And so you can see from the table of contents that what they've chosen to spend the largest chunks of page space on are the forum nonconveniens argument, the issue preclusion argument, the failure to prove actual malice argument, the exclusion of the medical records, and the argument that the damage award was excessive. So all of these other issues that they've raised with, this piece of evidence shouldn't have come in and Johnny should have, had to answer this question. The statements are really opinion and not fact claims at all. These get such short shrift in the brief that you can almost kind of assume that everybody knows these are throwaways. They're not taking the time to develop this into something that is persuasive. As a result of that, you also see some shortcuts in the analytical process that they present to the court. So instead of, for example, illustrating why a certain conclusion should be reached, they'll just come in and say, well, obviously, clearly. And we've talked about that before. These are words that you want to use very sparingly in an appeals brief because, quite frankly, rarely are things obvious. Usually, if you're on appeal and you're dealing with an issue that is a winnable issue, that means there is some ambiguity to it. Because they're trying to just talk about so much in so little time, they don't have the ability to explain why is it obvious that when Amber Heard says, I spoke up against sexual violence, that was true. They didn't have the space in their statement of facts to be able to go over a lot of these details of the allegations, a lot of the evidence, both for, both against. And so that just leaves them in this situation of kind of throwing it out there and hoping the Court of Appeals sees it their way. But if the court doesn't necessarily follow right along with them from the outset, they really haven't given the court anything to help lead them to that conclusion. This economy of expression and selection of what to include and what to omit is very, very evident in Amber Heard's statement of facts. Now, it is very much the purpose of writing a statement of facts to highlight your client's position, to write it in a way that shows the stuff that is favorable to your client and minimizes the stuff that maybe isn't so helpful. There's also really no point in talking about a lot more than really what your appeal is focused on. For example, if they're not going to argue about, say, Kate James's deposition, then there isn't necessarily any reason to talk about Kate James's deposition in their statement of facts. So the fact that it is targeted and tailored and refined is normal. But there is, a little bit of a problem here as well, which is that you still have to maintain your credibility with what you choose to include and what you choose to omit. They've written this statement in such a very one-sided fashion that it's not going to be very difficult for Johnny Depp to be able to come back and provide the court with the additional facts, the ones that Amber Heard left out because they didn't look good, they didn't help her position, and basically paint a completely different picture of what happened in this case and what happened at this trial. So that's one of the big downsides of this approach that they've taken, because they're so constrained and they have to make these editorial choices about what do we put in and what do we leave out. The stuff that you leave out can really have a huge impact on your credibility with the court. In the argument itself, they organized their topics by the remedy that each error would give if decided in Amber Heard's favor. And I thought this was a pretty smart decision because it does help. It helps the argument flow a little bit better. It helps with the reading and the understanding of what it is that you're asking the court to do and why. So the first issues that they present are all issues that, if decided in Amber's favor, would reverse the judgment and potentially dismiss some of the causes of action. If the court isn't willing to go down that road, doesn't believe that these particular errors occurred, then they're going to look at errors that would still reverse the judgment, but would just send the case back for a new trial. And these are largely the evidentiary types of complaints that she has. And then very lastly, even if all of that stands, nevertheless, the argument that the verdict should be reversed because it was excessive. I do think this is smart. I think that courts looking at appeals are often thinking in terms of what is the remedy, because that's the practical question. What's going to be the consequence of a decision that we reach here? We like to think, and we want to think, that courts decide legal questions purely based on the black letter law and the abstract level reasoning that they apply to it. But I think, frankly, that would be a little bit naive. The courts are aware that this was quite a process that Fairfax County went through for 6 weeks. And so if we're going to enter some kind of ruling that would require doing that all over again, they're aware of the burden that is. It's not that they won't order that. Of course they will. But it just maybe is a little bit harder to convince them to take that step in certain situations, especially if it's a close call, if it's not really crystal clear that you're entitled to that relief that you're asking for. So this gives the judges a nice framework to be able to work through. Okay, are we going to throw anything out? Are we going to give her a new trial? Are we going to reduce the damages award? And it lets them apply that practical type of mindset to their review of her briefing. Now, guys, just like with Johnny, I am not going to get into the weeds of the legal issues at this point in time. I'm going to wait until the response briefs are filed. Having said that, there are a couple of comments that I will make. Number one, no, don't think any of these things are going to be winners for Amber. We'll talk about more of the details why at a later point. But ultimately, there is nothing in here that jumps out at me as being particularly compelling in her favor. I did notice something that just struck me as a little bit odd. That's here at page 18, where she decided to invoke Christine Blasey Ford. This, to me, is a very peculiar choice. Christine Blasey Ford, you may remember, accused Judge Brett Kavanaugh of sexually assaulting her like 40 years ago during his confirmation hearings in the Senate. There was some political maneuvering that led to her being called to testify. She testified. People had various impressions about her credibility and veracity. So the choice to invoke her as sort of a figurehead for public accusations, I just found that to be a little bit strange. Normally, it's kind of prudent to stay away from political hot button things in your briefing because you just don't know what the sympathies of the judges who are going to end up on your panel are going to be. And so you don't know if the judge is going to look at this and think, oh, yes, Christine Blasey Ford, she was so brave and Amber Heard is just like her. Or if they're going to look at it and think, Christine Blasey Ford, yeah, she's the one that got up there and was talking about how it was indelible on the hippocampus. Is that the kind of thing that Amber Heard was trying to sell to this jury here? No wonder she lost. You really don't know what their perspective is going to be. So it's a risky analogy, and the choice to use it, it's a little bit of, I don't want to say a dare, but it's definitely laying down a marker in terms of the political orientation that they're bringing to this briefing and that they are at least hoping the court is going to share with them as they evaluate the case. The final thing that I'm going to comment on here is that you can often tell what the weak point of a person's argument is by what they choose not to say, right? If you don't have a good counter argument to a position that is very damaging to your case, then it's fairly common to try to just bury that or pretend it doesn't exist, not address it. So in Amber Heard's case, we definitely have one of these issues that is screaming by its absence, and that is harmless error. And so any type of trial error, in this case, all of these evidentiary issues that she's raised, the burden is always going to be on the person who is arguing that this was an error to prove it had an impact on the trial. And here's why. Again, this is something we've talked about before, that people aren't guaranteed a perfect trial under the Constitution. You're just guaranteed a fair trial. And so sometimes mistakes will happen, but it's kind of a no harm, no foul rule. If it wouldn't have mattered if the decision had gone the other way, then the Court of Appeals is not going to send it back for a retrial just based on the principle of the thing. They care about the practical reality and the impact that that decision had on the trial process as a whole. So harmless error is shockingly absent from Amber Heard's brief and her analysis. There's probably a few reasons for that. The space limitation is a huge one. Harmlessness of an error depends on the entire context of the trial. And so if you want to say that Amber Heard should get a new trial because Johnny Depp wasn't compelled to answer a single question during his cross-examination, you need to put that question and the potential answer to that question in the context of everything else that came out during the six-week trial. And you need to explain, why is this particular statement a game changer? Same thing, quite frankly, with like these medical records and stuff that she's arguing about. The jury already heard most of this stuff. They heard from Dr. Hughes what Amber Heard was telling her therapists. They heard from Amber Heard what she was reporting to the medical providers. They saw some of the medical notes, heard from, Nurse Erin, Nurse Debbie, Dr. Kipper. So you really have a harder time making a case that there was one specific thing that, would have really tipped the scale in this case. If you had that thing, you would be able to very clearly identify it and very clearly articulate why it's a game changer. But we don't see anything like that in her argument. She just basically talks about these things in generalities, doesn't get into the real specifics for the most part of what exactly it was that she thought should come in, and then only, very passingly at all talks about how it could have had some type of impact on the trial, and it's in this very conclusory fashion of it was unfair that she didn't get to do that. But if it wasn't going to change the jury's mind, considering everything else that they saw and heard over the 6-week period, then it's not going to get you a new trial. So the fact that they basically didn't even bother to talk about harmless error, to me, screams that they know this is a weak point. They don't want to talk about it. They don't have the time to talk about it. And so once again, by and large, then this whole section of their brief dealing with these trial issues, it's a throwaway. So the bottom line here, this is very good legal work. It is high quality. It is what I would expect from these caliber of attorneys. They've kept it very focused, very organized, very sharp. But again, they are just going to have a hard time getting past this strategic shooting themselves in the foot by spreading themselves so thin across so many issues that they just can't devote the time and the space that they need to really flesh out the arguments on the issues that they have the best chance of winning. So by and large, no, I don't think Amber Heard is going to win this appeal. I think it's possible that Ben Shu is going to have a lot of fun responding to this brief, because they've had to be so cursory with their treatment and so selective with their facts and evidence, that for him to be able to go in and fill in those gaps, it's really an invitation to tell the Court of Appeals yet again, now there's this whole other story here, a story about a hoax. So let's talk about the hoax and analyze her arguments of error, bearing in mind that part of the case and everything that the jury saw that tended to point in that direction. So we'll see, but I am looking forward to seeing the responses. Guys, I haven't forgotten as well that there's still a second amicus brief for me to talk about. I just had a little bit of a busy week this week, so I am hoping to get some more things out in the coming days, but the appeal will roll on and materials will continue to be filed, and I'll be continuing to take a look at them as they do. So again, once we get the responses, we're going to deep dive into these legal issues. So do stick around if you are interested in that, and I will see you in the next one.